On this episode of Law Weekly, we talk issues of removal of subsidy and its effects, fuel price hike, and the rising trend of children of retired and serving judicial officers being appointed to the bench. We have the views of a King's Counsel and Senior Advocate of Nigeria, Professor Fidelis Odita. Also showing on the program, retired Justice of the Court of Appeal, Justice Peter Ege, seeks more time for the Appellate Court to determine appeals from election petition tribunals, insists they need more than the statutory 60 days required. Plus a recap of some of the top trending legal stories in the news. Hello and welcome to the program. I am Shola Shoyeli. Recent decisions taken by President Bola Tinubu, particularly on issues of fuel subsidy and the floating of the naira, have been described in some quarters as poorly thought out and lacking proper legislation to back them up. This is the starting point of my conversation with King's Counsel and Senior Advocate of Nigeria, Professor Fidelis Odita.
I'm not sure about proper legislation because the subsidy is a matter of appropriation and no money was appropriated after June. So insofar as the matter rests on legislation, there is in fact no legislative support for subsidy. As regards the flotation of the naira, I think that's slightly different. That's a matter of monetary policy of the CBN and is within the remit of the CBN to manage Nigeria's exchange rate, monetary policy, and so on. So it's covered by an appropriate legal framework. What people might say is that both policies have occasioned a lot of hardship, and one has to say that that is true. I think the one about the foreign exchange is particularly important because the removal of a segmentation has meant that the importers and the exporters window is almost at the same rate as the parallel market. I think that that is a sensible thing because what the previous administration did was to encourage arbitrage. You buy naira at 420 to 1 and you resell at 800. So if you have access to the central bank governor or the presidency, someone will give you $5 million today and you could sell each dollar for almost 400 naira profit. So when you multiply that by 5 million, you see you've made a lot of money. I don't think that any sensible system can encourage that level of arbitrage. In fact, that is not even arbitrage, that's fraud. The petrol is a different thing. You know, the problem we have in Nigeria is that however sensible a policy is, the public servants undermine it. And the difficulty is that however good your policy is, however well articulated, no policy is self-implementing. And we as a nation have failed to implement, whether it is laws, policies, call it what you like. And that's the same problem with subsidy. Instead of a subsidy bringing down trickle-down effects for the benefit of the masses, the fraudulent elites were skimming off the cream of a nation in the name of subsidy. They were those being subsidized. And even now that petrol has gone up to about 500-600 naira, it's still relatively cheap because internationally, yes, it's not up to $1. I don't know anywhere you can buy a liter of petrol for $1. Not even in America, not in Saudi Arabia, certainly not in Europe. But as a poor country, $1 a liter is not bad. The challenge is that people don't earn $1 a day. And the idea that your daily effort cannot buy you a liter of petrol is very, very shameful and is most unfortunate. It shows the extent to which the country has been mismanaged by successive governments.
The palliative that's been proposed by the government, even though now the government is trying to work its way back on that, and the 70 billion naira, when you put it side by side with the 70 billion naira that the lawmakers have budgeted for themselves, do you think that it amounts to a risk of insensitivity on the part of the government, or Is it as a result of the structure of government that we run?
I think what that shows is the level of impunity that exists. You could also say impunity coupled with insensitivity, but I don't see it as insensitive because that assumes that those lawmakers are outliers and no one controls them, whereas that is not the essence of democracy. We entrust power to them to exercise power on our behalf, and there is no way they can appropriate to themselves the wealth of a nation the way that they have. I used to be very sympathetic to the cries of people. But when I watch electoral patterns and all the people you're trying to protect, by the time election comes, they vote for the same people. These people who have just come, you're telling people you want to give them 8,000 naira a month. And then on the other hand, less than 500 people have appropriated to themselves 70 billion in the same country. And no one is saying anything about it. And the masses themselves, who are supposed to have the power of control through the electoral box, are doing nothing about it. And come the next election, or if there is a rerun election, they will still do the same thing. So you can't continue to behave in the same way and expect change to come your way.
Some commentators have said that the current reality in Nigeria today is that the country has no system that can deliver a workable palliative because of endemic corruption on one hand, and some others say that because there's no workable data. Do you agree, or what solution do you see?
I think that what the government should do is really to invest in infrastructure, do hospitals, do more roads, do schools, things that on their own will create employment and also create capacity so that people can go out there, do something for themselves and earn money. The idea that you're going to give someone 8,000 naira a month, which is not going to buy them one chicken, is just a joke. It's so laughable. I mean, it shows that we're not serious people. And you'd have thought that Mr. Tinubu and his team of economic advisors are serious people. But obviously, whoever came up with paying 8,000 naira a month to poor people who are not identified, who may well be, for all we know, members of APC, as if the country belongs to the APC. It's just such a poorly thought out, will be very poorly implemented, and I think it's better abandoned.
Prof, let's come now to talk about the judiciary. Senior Advocate of Nigeria, Riafe Babala, recently at the celebration of the 60th anniversary of his call to bar, called for the exclusion of sitting judges from the election petition tribunals because, of course, we all know that most of the judges are busy with election petitions, and that has taken them away from the regular courts. He suggested that the proceedings of the tribunals should be presided over by a committee of senior lawyers and retired judges. Do you think that this is something that would work?
It depends on what the problem is. If the problem is corruption of the members of the tribunal, obviously getting retired judges or senior lawyers isn't going to address that, because retired judges will even be under more pressure to take money, free from sanction of NJC or any other disciplinary body. The senior lawyers will also take money. So insofar as the problem is corruption, the proposal of Chief Afebabala won't work. But to the extent that he's trying to address the dislocation of a civil and criminal justice system arising from the diversion of large numbers of judges to electoral duties, then of course there is a point about that, because anyone who goes to the courts will see the paralysis which is now attending all the courts, because the judges part heads or abandoned ship and gone to the electoral tribunals. Very disruptive. But it also shows how everyone is working for the politicians.
So what will work?
I think the first thing that will work is to ensure that the elections have integrity and that they are transparent. But if you don't get your elections right, and then you leave it for the courts, you're going to inundate the courts. The real culprits are the politicians and INEC. So what's wrong with people coming, voting in a transparent system, counting, recording, and declaring? So you see who the victor is. But where the INEC goes, scrubs up this, scrubs up that, refuses to do that, you encourage suspicion, you introduce fraud, and then, of course, people feel that they have to have a go and go to tribunals.
So what reforms do we put in place to guarantee credible elections?
Is to jail the INEC chairman, first of all. And all the people who have led or caused the elections to fail. People who have abused their powers, whether knowingly or unknowingly, whether for gratification or gratuitously, people who have abused their powers. Unless you can reform the administration of electoral laws and the elections themselves as processes, there is no solution. So every organized society where there is rule of law and where things work as they should depend to a large extent on voluntary compliance. The problem we have in Nigeria is that the electoral umpire that is supposed to be independent and impartial is neither independent nor impartial. And therefore, you feel as a politician, as an actor in the political process, you feel hard done by, and therefore you take your complaint to the court. And it's even worse in Nigeria, where before you challenge electoral malpractice, they say, go to court. Just let us rule, go to court, in a derisory manner, because they know you are not likely to get anything from the court. And I feel ashamed for those judges, because the cliche go to court has become a cliche for the impoverishment and the lack of capacity and lack of effectiveness of the courts.
You say jail the INEC chair. On what charges?
You jail the INEC chairman on the basis that, first of all, the Electoral Act of 2022 provided that INEC will issue guidelines for the conduct of the elections, and they issued the guidelines saying this is how the results will be uploaded. And so, if the results had been uploaded instantly so that everyone can see what's happening, there won't be as many petitions as there are. It doesn't matter who wins. People get fixated about this person winning. That's not the issue. What we need is integrity of the process. Because if the process is credible, we will accept the outcome. But when the process is riddled with fraud and other inefficiencies, you can't accept the outcome. And that's just a fact of life. So that's one. And two, when you say these are your guidelines, you must follow those guidelines, because those guidelines create legitimate expectation in us as the electors, in those who participate as candidates, that this process will be followed. But where that process is not followed, and there is no reason, you just say there was a glitch. We're not in 1910. Come on. So you need to jail him. You need to remove him. He even needs to resign. But the problem in Nigeria is we don't have a culture of people resigning because everybody acts with impunity.
I hear what you say about the perception of the judiciary and how it makes them look, but this trend where children of sitting and even retired judges are appointed to the bench, what do you make of it? Recent case in point is the son of the Chief Justice of Nigeria, who was last week appointed a judge of the Federal High Court. It's become a major talking point among lawyers in the country.
Of course, you can start from wherever you like in relation to that question. You could say, of course, the children of the CJN, they are qualified. The children of those judges, the qualification is 10 years post-call, and I'm sure they're all 10 years. But that's really not the point. I think it's a real shame that we have given enormous powers to judges, and they, like the politicians, have abused the powers. And you can say to yourself, if the predecessors of these little judges who are putting their little children in those positions had done the same thing, many of these judges will never be appointed. Every system thrives on merit, so you have to take your best. If you are going for the Olympics, for example, you have to select your best. If you are going to a football tournament, you have to take your best. The idea that in this sphere, you don't need your best, anyone can do it, is just a joke. And we have seen the calamity which comes with it. I think it is just disgraceful. And it shows abuse of power. The judges themselves, who are there to correct abuse of powers by the other two organs of the government, are themselves engaged in even more egregious abuse by trying to self-perpetuate, to clone themselves. They finish serving incompetently, then they put their even less qualified children to continue. And they expect the society to work. They can't work. Where people serve their own interests in the name of public service, the society is doomed. And that is what we have with this. Of course, it is not such a widespread thing, but the examples are enough to show that the judges simply do not understand the ethics of what. They just like the authority and the power without the responsibilities and the constraints which come with the affords.
There's a hopeless situation.
It is not a hopeless situation. What they need to do is really to change the appointment system. The way that some of these problems existed in Kenya, they changed it. Once you open up the appointment system, you get the best applicants. What's the point about you want to get the most senior judges and you just say you want to get from the 6 geopolitical zones? Let's even assume that that itself is a worthy policy to pursue. But you don't open up the competition. It's people from the Court of Appeal that, it's just a system of promotion.
Thanks for staying tuned. Retired Justice of the Court of Appeal, Justice Peter Ige, has advocated for more time for the appellate court to determine appeals from election petition tribunals. He made this submission in Ibadan during a valedictory court session held to mark his retirement from the bench. The event was attended by other justices of the appeal court, justices of other courts, members of the bar, family, friends, and well-wishers of the retiring judge. The retiring judge, Justice Ige, was sworn in as an Oyo State High Court judge on June 27, 2001, and elevated to the Court of Appeal on October 31, 2012. He retired as a judge of that court on Wednesday, July 12, after clocking the mandatory retirement age of 70. At the valedictory court session held in his honor, Justice Ige said instead of 60 days, the appellate court would need about 80 days to hear and determine election petition appeals before it.
I believe very strongly that the appeal from election tribunal to the Court of Appeal, the date should start to count from the date the appeal is entered at the Court of Appeal. So if the 60 days start from there, at least if you remove 7 days, 5 days, and all the rest, we will still have about 20 days or 25 days to look into the case the appeal and render judgment. So I suggested to the National Assembly that it is high time they amended all these sections dealing with appeal to the Court of Appeal, especially in appeal from election petition tribunal to the. So, or the alternative, they can increase the 60 days to 80 days. That will also meet the justice of the matter.
In an interview with Channels Television, the retired judge also speaks more about some of the reforms he would like to see in the judiciary.
The judiciary needs to be strengthened because the manpower is lacking. Because you can see that a situation where 10 justices will be performing judicial function of 50 justices. If you look at Supreme Court, for example, you have almost 12 now remaining. So very soon there will be new appointment to the place. But even then, the Constitution talk of 21 justices. But I believe very strongly that there is nothing wrong if the Supreme Court they can have divisions like you have in the Court of Appeal. The Supreme Court too can have divisions, especially in the 6 geopolitical zones of the country, so that it will be like taking justice to the grassroots. And most of the Court of Appeals there will serve the justices or the division of Supreme Court that will be cited in those zones. Then the same thing, the Court of Appeal. So the Court of Appeal have been depleted due to retirements and deaths. So, and most of the time, the workload in the intermediate court is very, very heavy, very, very heavy. So we need more justices to be appointed to the Court of Appeal. At least not less than 150 justices instead of the 90 that we have now. So we have 20 divisions already. So at times you have only 3 justices in some of the divisions. And divisions like Abuja, like Lagos, like Kaduna, like Port Harcourt, they are very busy divisions. So such divisions ought to have at least 2 standing panels at all times to sit in those divisions. So you need not less than 15 justices to be in each of the 4 divisions that I mentioned that have a great workload in the Court of Appeal. So I call on the relevant authorities to increase the funds being given to the judiciary so that at least everything can be put in place to have an orderly, peaceful, tranquil citadel of justice all over the country.
And just before we go, let's quickly do a recap of some of the top trending stories from the courtroom.
We begin with the report that the Federal High Court, Abuja, has threatened to issue a warrant of arrest against the suspended governor of the Central Bank of Nigeria, Godwin Emefiele, over his failure to appear in court to explain circumstances surrounding the $53 million judgment debt arising from the Paris Club refund. Justice Iyameko, who ordered Emefiele to appear on the next adjourned date, said he was minded to exercise restraint in the proceeding to give the former CBN boss an opportunity to explain himself. This follows the intervention by his counsel, Audu Anuga, who asked the court to give Emefiele another opportunity. Mr. Anuga told the court that Emefiele has been in detention since his removal, and all efforts to reach him to communicate the directive of the courts to him have so far been unsuccessful. Meanwhile, the suspended CBN governor has asked the Federal High Court sitting in Lagos to admit him to bail on self-recognition pending the hearing and determination of the charge of illegal possession of firearm and ammunition filed against him by the federal government. Some constitutional and human rights lawyers have also filed a contempt case against the Director General of the Department of State Services, Mr. Yusuf Bichi, for what they described as a violation of multiple judgments and orders of court, directing the release of the former central bank governor from the custody of the agency. Staying in the nation's capital, Abuja, the Economic and Financial Crimes Commission EFCC has arraigned a former Minister of Aviation, Senator Stella Odua, before the Federal High Court on a 25-count charge. Mrs. Odua, who served as Aviation Minister from 2011 to 2014, is facing trial over allegations that she laundered public funds to the tune of about 5 billion naira in connivance with 8 others. They were accused of violating Section 11, Subsection 1 of the Money Laundering Prohibition Act 2011 and punishable under Section 11, Subsection 4A of the same Act. They were equally accused of opening a United States dollar anonymous private banking nominee account with First Bank, among others. They all pleaded not guilty to the 25-count charge. And to election petitions, an official of the West African Examination Council, WAEC, Olufemi Olaleye, has appeared before the Election Tribunal sitting in Abeokuta, the Ogun State capital, but failed to tender a copy of Governor Dapo Abiodun's WAEC certificate. The Examination Council had earlier been subpoenaed by the tribunal to produce a copy of Abiodun's 1978 WAEC certificate as attached to the form he filled with the Independent National Electoral Commission (INEC). The governorship candidates of the PDP, Ladi Adebutu, had alleged that Abiodun forged his WAEC certificates. In Enugu State, the Department of State Security, DSS, has debunked claims by the National Youth Service Corps, NYSC, that the governorship candidates of the People's Democratic Party, PDP, in the 2023 general election, incumbent governor of the state, Dr. Peter Mbah, forged his NYSC discharge certificate. The DSS made this known in a statement on oath adopted by its representative, Mr. Yahya Issa Mohammed, at the Enugu State Governorship Election Petition Tribunal. The DSS indicted the NYSC on its conclusion that Mr. Mbah's NYSC discharge certificate was fake, saying that certificates in Mbah's series were found to have been issued to corps members in Lagos, contrary to NYSC's claim. Meanwhile, the Enugu Division of the Court of Appeal has dismissed the suits filed by the governorship candidates of the All Progressives Congress, APC, in the governorship elections in Enugu State, Chief Uche Naji challenging the victory of Mr. Peter Mbah. Let's round off the news update in Cross River State, where the Governorship Elections Petitions Tribunal has dismissed a petition filed by the New Nigeria People's Party, NNPP, against Governor Basio II of the All Progressives Congress, APC. The NNPP, alongside its governorship candidate Wilfred Bonse, had filed its petition on April 10, 2023, alleging substantial non-compliance with the 2022 Electoral Act. The party sought a declaration by the court that the non-inclusion of the party's logo on the ballot paper used for the election was unlawful. The NNPP also wanted a declaration by the tribunal that the Independent National Electoral Commission (INEC) should conduct fresh governorship elections in Cross River State. In a unanimous judgment, however, Justice Okenine said the petitioners failed to establish that the candidate was lawfully excluded and dismissed the case in its entirety.
And that's the program for today. If you missed any part of it, you can find it in past episodes on our YouTube channel. Do also give us feedback via any of our social media platforms. I'm Shola Shoele. Thank you for watching and see you next time.